Lordships will correct it in judicial review. If the speaker has failed in his duty, my lord, in all these judgments, where your lordships have upheld disqualifications, where the speaker, my lords, had refused to adjudicate on disqualification, your lordships have disqualified them. Will the ECI, my lord, be justified in applying the test of legislative majority? Lord, the Supreme Court in Subhash Desai said they will not be justified. Even if your lordships are pleased to hold that the order is illegal, Lord, it will have a definitive impact on the symbol dispute. That's all I wish to say. Yes, Lord.
There is no dispute that Mr. Sinde had legislative majority.
Correct, Lord. That in paragraph 15, my lord, the essence of the dispute is to find out who really is the lifeblood of the political party. In that sense, my lord, that lifeblood is recognition of de facto state of affairs. So, my lord, the inquiry as to whether, my lord, the constitution is de jure, whether your conduct is de jure, etc., that can't be the test at all. Subhash Desai said you have to find out the lifeblood, who are in majority, who constitute the heart and soul of the party. That's one of the principles. Why are we discussing the disqualification? Because the period is already over. And my lord, my learned senior colleague already hinted that, my lord, pursuant to a constitution bench judgment in Rana, and, my lords, followed by a 3-judge bench in Srimant Patil, your lordship's court have already taken a view that, my lord, the final verdict regarding disqualification is only an ex post facto recognition of the fact of disqualification which has happened. Now, here, my lord, the acts alleged have happened between 21st of June till 4th of July. So, if your lordships are pleased to hold in our favor, then, my lord, the declaration would go back. So, that's the first point, my lord, and I have, my lord, extracted the relevant submission observations of the court. If your lordships are pleased to have, my lord, page 2 of my note, the outcome of the present petition has a direct bearing on the symbol dispute. And, my lord, the relevant portion of the judgment in Srimant Patil, my lords, I'll just place that. My lords, that is the in paragraph 6. In addition to the above, the decision of the speaker that a member is disqualified relates back to the date of disqualifying action complained of. The power of the speaker to decide upon a disqualification petition was dealt by a constitution bench in Rana. This court, reading the provisions of paragraph 2 and 6, has clearly held that the speaker has to decide the question of disqualification with reference to the date on which it has occurred. So this is the relevance part.
But can we declare him to be disqualified today?
Yes, my lord.
The speaker having not declared him disqualified erroneously or other.
Yes, my lord. My lord, the submission would be this.
Because we are not an appellate body.
Yes, my lord. But ultimately,
exercising judicial.
Correct, my lord. Ultimately, my lord.
Decide quash an order.
Yes, my lord.
Order is illegal.
Yes, my lord.
But can we assume the role of the speaker and disqualify?
My lord, ultimately, my lord, the list was alive when we, my lord, filed the SLPs. And, my lord, the judicial review in.
Here yes. In what I
yes, no. Yes. No.
If an order is challenged in judicial review,
yes, no.
and the order is found to be perverse,
correct,
illegal, no. We can set aside the
yes,
order and remand the matter for fresh consideration in terms of the direction.
Your lordships have also said, my lord, in disqualification matter.
Correct.
But
can we assume the role of the speaker,
my lords, and
say that he is disqualified and would be deemed?
My lord, in all these cases, my lord, where disqualification, my lord, was ruled out by the speaker, when the matter came up in appeal, your lordships decided it and said, my lord, that he is disqualified. Lord, your lordships exercised power, my lord, of judicial review. And in 110, 111 of Kyoto, your lordship said that, my lord, judicial review is limited against the order of a speaker. Absolutely. If the order of the speaker is perverse, which we will demonstrate.
Restrictive role of
yes.
a cassation court,
yes, ma'am.
Unlike an appellate court,
yes, ma'am.
Is to assume the jurisdiction of the court of
correct,
justice.
Correct. But so therefore, my lord, the speaker's order, my lord, emanates as is, my lord, it's not, my lord, in the capacity of the, my lord, leader of the house. My lord, it is a tribunal. So therefore, my lord, when the tribunal has acted with perversity, I'll cite that paragraph, my lord, that your lordships will correct it in judicial review if the speaker has failed in his duty, my lord. And your lordships can also give the relief.
That is what we say.
Yes, my lord.
That question. We have no doubt in our mind.
Yes, my lord.
that if the approach of the speaker is contrary to law, and
Correct, my lord.
Mr. Hon'ble has argued before us
Yes.
very eloquently that Subhash Desai principles were
Correct,
not
my lord.
considered or considered incorrectly. We are with him, we set aside.
Yes, my lord.
But can we say that consequentially we declare him disqualified?
My lord, the reason will be that, my lord, although the effective relief will not be there, because, my lord, under 194, my lord, the term of the assembly, my lord, is what is relevant. My lord, it will be a disqualification, a declaration will be given, my lord, but with no consequent relief.
No
Lord,
consequent relief.
Lord, even in, my lord, 356 matters, your lordships are aware. SR Bommai, my lords, was decided much after the, my lord, yes, my lord.
It's a much limited
Correct, my
area.
lord. But the declarations were given, but in view of the fact, my lord, that assembly elections were held. Yes, I'm sorry.
In fact, 356 is not even a comparable.
Correct, my lord. It's much higher, my lord. It's much
Much
higher.
higher.
Much higher. So this is, we are dealing with the tribunal's order, my lord.
Constitutional power
Yeah.
exercise, very limited area.
Correct, my lord.
Speaker is exercising quasi judicial power.
I'm grateful, my lord.
Doubt
Grateful.
in our mind,
Correct.
and we have also no hesitation
Yes.
to issue a writ of certiorari order.
Yes, my lord.
The question is, can we issue a writ of mandamus and say that he shall be deemed to have been declared?
My lord, once the declaration is given, my lord, your lordships will also clarify. I'm sorry.
Mandatory order can be given.
My lord, I am
Because
only.
in doing that,
Yes.
we would convert ourselves from a court of review to a court of appeal from the order of the Speaker,
My lord, in
which
all
the
these,
Constitution did not provide to us.
my lord, in all these judgments, where your lordships have upheld disqualifications, where the speaker, my lords, had refused to adjudicate on disqualification, your lordships have disqualified them. Exercising, I'll make a chart, my lord, and give it, my lord, so that, my lord, my lord, as far as that is concerned, my lord, we'll give judgments and the paragraph number.
Just wanted
Yes,
to
my lord,
check
including.
because of
Yeah.
this unique factual situation.
Yes, my lord. But ultimately, my lord, if your lordships have the power to give a declaration, the fact that the term of the assembly is over.
Doubts.
Yes, my lord. So
There is no doubt
Yes, ma'am.
that we can caution set aside the
Correct,
order, dismissing the
Yes, ma'am.
disqualification.
Correct.
And say that it was incorrectly decided. Wrong parameters, etc.
Yes, my lord.
etc.
Now, my lords,
Can we? The next thing is what? On the
Yes.
resultant. Yes.
my lord, the reason why I'm saying, my lord, even if your lordships are pleased to hold, my lord, that the.
Just consider a situation,
Yes.
again, not very comparable,
Yes, ma'am.
in a disciplinary proceeding.
Yes.
Someone is given disproportionate punishment. We can cost the punishment. Can we impose the punishment? We have to remand it again, consider, ask the disciplinary authority to pass appropriate order
Yes, ma'am.
in accordance with the direction.
Yes, ma'am. But
Scope, having gone because of the expiration of the tenure, whether we can declare him.
my lord, even if, my lord, I bow down, my lord, to what is falling from your lordships, if your lordships are pleased to hold that, my lord, the disqualification petitions were incorrectly decided, my lord, let's assume that, then, my lords, it will have a definite bearing, my lord, on, my lords, the symbol dispute. Because in Subhash Desai, my lord, this very conundrum, my lord, which there are two parallel proceedings, my lords, one disqualification, one ECI. Will the ECI, my lord, be justified in, my lord, applying the test of legislative majority? My lord, the Supreme Court in Subhash Desai said they will not be justified. So therefore, my lord, yes, my lord. So therefore, even if your lordships are pleased to hold that the order is illegal, my lord, it will have a definitive impact on the symbol dispute. That's all I wish to say. Yes, my lord.
There is no dispute that Mr. Shinde had legislative majority.
Correct, my lord. Correct.
But the question is, when he assumed legislative majority,
Yes.
did he remain the party?
Correct, my lord.
Remain the party.
Correct, my lord. Lord, as far as the disqualification is concerned, Lord, that question will be entirely irrelevant. Now, my lords, there are a few principles, my lord, in Subhash Desai, which really answer this. My lord, those paragraphs I don't wish to point out, but please have a look at, my lord, I've made, my lord, a chart of what the principles are and with references to the paragraph numbers. I have placed it under 4 headings, my lord, in paragraph 8. If your lordships are pleased to have paragraph 8, my lords, at page 3. Not the first principle my learned senior colleague Milord has already dealt with, that the political party and legislature party are two different concepts. But one thing, Milord, if your lordships are pleased to turn to page 4, principle G, a legislature party cannot set up a candidate. Your lordships got that, Milord? That is, Milord, in 116.1, in page 4 of my note, Milord, in paragraph G on top, Milord. Now, Milords, this is relevant because, Milord, the Constitution 10th schedule, by a deeming fiction, Milords, in the explanation, clearly states who is the original political party. And that is, Milord, whichever party, Milord, has set that candidate as far as the election is concerned. So Subhash Desai is very clear that a legislature party cannot set up a candidate for election. If that be the scope, Milord, then the inquiry as to, Milords, whether the legislative majority can constitute the political party is entirely beyond the ambit of the 10th schedule, Milord. So that is point number 1. Then, Milords, kindly turn to the second set of principles. The purpose of symbols order and the effect of the decision under paragraph 15. Now, Milords, if your lordships are pleased to see C in this, item C, the substance of the decision under paragraph 15 is which of the groups is the lifeblood of the political party. Now, this is very important, Milord, because your lordship's court felt that in paragraph 15, Milord, the essence of the dispute is to find out who really is the lifeblood of the political party. In that sense, Milord, that lifeblood is recognition of de facto state of affairs. So, Milord, the inquiry as to whether, Milord, the constitution is de jure, whether your conduct is de jure, etc., that can't be the test at all. Subhash Desai said you have to find out the lifeblood, who are in majority, who constitute the heart and soul of the party. That's one of the principles. Now, kindly see, Milord, the heading 3. Milord, this is what I was, Milord, attempting to submit. The potential for complications where there are simultaneous proceedings of paragraph 15 and the 10th schedule. Now, this is a heading in Subhash Desai, and the relevant paragraphs, Milord, I have cited. Scenario A, ECI gives its decision first, which has happened in our case. Scenario B, Speaker gives its decision first, which has not happened. Now, kindly see, Milord, the next. If the faction which enjoys the majority in the House is disqualified after being adjudicated to be the political party, the very foundation of their claim, being the political party, no longer subsists. This is not a constitutionally desired outcome. So, therefore, in our case, Milord, where the disqualification has happened after the ECI, and, Milords, if your lordships are pleased to then hold that, Milord, this disqualification order is not correct, then the reliance by the ECI on the legislative majority, Supreme Court says it's not a constitutionally desired outcome. Then, Milords, D is extremely important. And where, Milord, the Election Commission has gone completely wrong. And this paragraph, Milord, is paragraph 157, 158. In such circumstances, it would be futile to assess the legislative majority in paragraph 15, and the ECI should look at other tests. So therefore, Milord, the entire foundation, as your lordships have seen, Milord, from that 101, etc., in the Election Commission's order, entirely goes, because Supreme Court says you cannot have legislative majority test when there are parallel disqualification proceedings. Then, Milords, kindly see E. The decision of the Speaker and the decision of the ECI are based on different considerations and are taken for different purposes. Your lordship saw yesterday, Milord, that the Speaker cites, Milord, sadically and says, I will find out who is the party depending on legislative majority. Supreme Court says the tests are completely different. Then, Milords, F, the decision of ECI has a prospective effect. Milord, this is very thoughtfully, Milords, worded. Milord, the Supreme Court was conscious of the, Milord, difference in the nature, genre of proceedings as far as, my lord, the 10th schedule is concerned and the ECI, as your lordship, my lord, Justice Bagchi has been putting to us. My lord, the ECI proceedings under paragraph 15, my lord, is a proceeding of adjudication as to which of the rival factions constitutes the lifeblood of the political party. And, my lords, pursuant to that determination, the political leadership of that party can change. So, my lord, the status quo can be altered in a paragraph 15 proceedings. But as far as, my lord, 10th schedule is concerned, it is only identification, my lord, of who's the political party at the relevant time. So there is a complete, my lord, difference, jurisprudential difference between paragraph 15 and, my lord's, paragraph and 10th schedule. Then, my lords, the fourth heading. What are the principles which govern adjudication under the 10th schedule? This is Subhash Desai again. In cases where a petition is filed after the commission of prohibitory conduct, which is the, my lord, 21A and 21B, the decision of the ECI cannot be relied upon by the speaker for adjudication of the disqualification proceedings. Then, my lords, if the petitions are adjudicated based on the decisions of the ECI, in such cases, the decision of the ECI would have a retrospective effect, which is contrary to law. Then, my lord, C is also extremely important. And, my lord, this I am going to devote a little bit of time. My lord, Supreme Court says when the prohibited conduct is committed under the 10th schedule, there is only one political party. And the speaker has only to determine prima facie who the party was at the time when the prohibited conduct is committed. So, my lord, that prima facie determination is not adjudication. The speaker here, your lordships have seen, has gone on, my lords, adjudicating whether the 2018 leadership structure is valid, invalid, whether it is in conformity with the 99 Constitution. Prima facie determination would only mean, my lord, that under explanation of explanation A to para 21A, it says that whoever has set these legislators as candidates, that is the original political party. And that is seen, my lord, it's not, my lord, an inchoate concept. You just have to see under 29A, what is the leadership structure, who is the president, who is the secretary, and that is the leadership structure. And if, my lord, that direction of the political party has been violated, my lord, that's the end of the story. Where is the question of an adjudication? My lord, therefore, my lord, there is a complete jurisprudential difference, and he has conflated, my lord, the paragraph 15 adjudication and brought it under, my lord's 10th schedule.
शिवसेना नाम और चुनाव चिन्ह का विवाद सिर्फ दो गुटों की लड़ाई नहीं है, बल्कि ये देश के लोकतांत्रिक ढांचे और दलबदल विरोधी कानून की भविष्य की दिशा भी तय करेगा। माननीय सुप्रीम कोर्ट में चल रही तीखी बहस और विधानसभा अध्यक्ष की भूमिका पर उठाए गए इन गंभीर सवालों को आप किस नजरिए से देखते हैं? क्या आपको लगता है इस मामले में कोई नया संवैधानिक मोड़ आने वाला है? आपकी जो भी राय हो हमें नीचे कमेंट्स बॉक्स में लिखकर जरूर बताएं। जय हिंद दोस्तों।